Okay, welcome. My name is Sarah Weinstein, and I'm the Executive Director of Hemlock Society of San Diego. I'm so pleased to have so many of you joining us today for our webinar about Senate Bill 1196. We will have two presenters today, Marcia Hofer and Barry Price, both from A Better Exit, and they will be talking about the work that they have done to expand medical aid in dying. Marcia Hofer is the president of A Better Exit. Her first career was as a professional dancer. And then in her 30s, she went back to school and got a PhD in clinical psychology. As a psychologist, she worked with individuals, couples, and families of divorce that were dealing with child custody issues. When she retired in 2002, she planned to spend her post-work life focused on family, travel, singing semi-professionally, and gardening. Founding A Better Exit and working to expand medical aid in dying became an unexpected third career for Marcia. We'll also be hearing from Barry Price, who is a retired professor of political science. And many of you know Barry from the years that he spent as Hemlock Society of San Diego's president. His experience watching close friends suffer at the end of life has led him to devote years to educating our community on end-of-life options. He's an ardent advocate for broadening California's current medical aid in dying laws. So Hemlock Society is so pleased to have Marcia and Barry here to tell us more about their efforts, the efforts of A Better Exit, and the story behind this recent work and Senate Bill 1196.
It's great to have this opportunity to talk to you all about how we got started and what we've been trying to do. You know, I think almost everyone who's involved in this work has a personal story that has motivated them. And this is my reason. That's a photo of my husband of 52 years, Ricardo Hofer. You can take him down. He was a retired clinical psychologist, a voracious reader, and an avid amateur musician. And he had always said to me that if he ever developed dementia, as some family members had, he would absolutely not allow that disease to run its course and rob him of his autonomy, his personality, and his ability to make choices. So when he was diagnosed with early dementia in late 2020, we had a lot of thinking to do. We started having a series of family meetings with our two daughters and their partners. This was on Zoom. It was during the pandemic when we couldn't see each other in person. And we started talking about the options, and we realized pretty quickly that Ricardo's wish to die at home in his own bed was not something that we could legally and easily do. And so we finally made the decision to go to the Pegasus Clinic in Switzerland. The reason really comes down to one requirement in California's End-of-Life Option Act. I'm sure all of you know that we have this law in California. It was passed in 2015 and implemented in 2016. But it has one ironclad requirement that barred my husband from using it, and that is that a person requesting medical aid in dying must have a terminal diagnosis that will end their life within a period of 6 months. So clearly this means that no person with dementia can ever access the law, because long before they get anywhere near that 6-month mark, they will have lost the ability to express this wish and have the cognitive capacity to understand the consequences of using lethal medications to end their life. So this is why we went to Switzerland. And at we set a date several months out. It was a pretty intense time of saying goodbye to people, a lot of social events at home and family coming to visit from various parts of the country, goodbyes on Zoom and FaceTime. It was a very important time for my husband and for everyone else who participated in it as well. Ricardo died at the Pegasus Clinic with his family with him. Our daughters and their partners came with us, and he died peacefully, painlessly, and quickly. And he went out listening to a Bach cello suite, which was something he loved. So, as deaths go, it was really a good one, I have to say. When I came back, before I tell you about what happened when I came back, I want to tell you something else that happened kind of unexpectedly. The morning Ricardo died, the director of Pegasus asked him if he would be willing to record a little video interview. This was impromptu, and Ricardo said sure, he would do it. And I just want to read you a couple of sentences from that interview. He said, I firmly believe that this is a right that every human has to determine when and how to leave this life. I'm not committing suicide. I am committing to live my life to its very, very end with the same kind of values I've tried to exercise throughout my life. I hope that there will come a day when dying will be treated like any other human experience rather than something that has to be avoided at all costs. It cannot be avoided because we all are destined to die. The issue is how we die and with what kind of values. So when I came back from Switzerland, I started thinking about the fact that a person in the state of California should have to fly across an ocean to access an assisted death, something that I felt we really should have the right to do here. And one of the things I did was start looking around the web to see what organizations are out there in the arena of right to die, end of life. I was familiar with Compassion and Choices because Ricardo and I had donated to them for many years. But when I looked at their website, I realized that their main focus is uh, to continue to get more states to implement basically the same law we have. So of course, that still wouldn't help people with dementia or the other people who can't access the law because it would be basically a law with the same arbitrary 6-month requirement as an entry point. One of the organizations I came across was the Hemlock Society of San Diego. And when I looked at Hemlock's website, I realized right away that the way Hemlock approached the issues involved was very, very much in tune with the way I was thinking. So I joined Hemlock. And a couple of months later, this was in March of 22, I was invited to a Zoom for new members. It started with a presentation by Faye Gersh of the history of the right to die movement in the US, which was very useful. And then Faye opened it up and said, well, let's go around the Zoom room and introduce ourselves and say why we're here. So I said I had gone to Pegasus with my husband, and right away a message popped up in the chat for me, and the message said, we need to talk. I was at Pegasus with my mom a few months before you were there. That was a message from Christy Golomb. So Christy and I had a couple of phone conversations, and then Barry, who at the time was president of Hemlock, put us in touch with another Hemlock member, that was Leonard Levinson, who had already reached out to Hemlock with his desire to find a way to expand the law. So initially, Christy, Leonard, Barry, and I started talking. And then a couple of months later, we were joined by Janet Hager. In the fall of that year, Leonard decided to step back from active participation in the group, so the four of us became the core of what later became a better exit. So Janet, Christy, Barry, and I. It's probably fortunate that we had no idea what we were getting ourselves into in terms of the amount of work, or I think we would have just not ever attempted it, but in our ignorance, we plowed ahead. So there really were two major arenas we had to deal with. One was, how do you even start an organization? What do you call it? What papers do you have to file? We had to have articles of incorporation. We had to file with the state of California. We had to file with the IRS to get tax exempt status. Um, we had to land on a name that would sort of telegraph what we wanted to do. We had to get a website up. We had to figure out how to contact people and how to reach people to let them know we were doing what we were doing and ask them to support us in some way. So I will say, fortunately for us, we've had enormous help from a group of advisors kind of in the background, people who know about law, about the legislative process, about messaging, and they've been really immensely helpful to us. So as we were getting organizationally organized, we also had to tackle the really big questions of what did we want to do and how did we think we should do it, or how did we think we might be able to do it. We spent a lot of time talking about the specifics of what we thought should change in the California law. Of course, it's not only people with dementia that are barred from using the law, although we think it's probably the largest group of people who would choose to use the law if they could. But there are people with other progressive neurological conditions that can't use the law because by the time they qualify under that 6-month requirement, they aren't able to take the medication in the way that it needs to be taken. There are other people who suffer with intractable pain syndromes that aren't a terminal diagnosis, but that don't respond to pain medication and that make their lives truly a misery. So we thought that all of these people really should have the option of choosing a peaceful, dignified death when they need it. So we looked closely at the language in Canada's law. Canada has had a law since 2016, which has been working well, and they use in their legal language a phrase which is grievous and irremediable medical condition. And that language ended up in SB 1196. It's also spelled out quite specifically, and I'll talk about that later. But we we felt that the 6-month terminal diagnosis criterion had to be eliminated to allow access for the people we were concerned about. So that was going to be request number one. Request number two had to do with the way the lethal medications are administered. Because of the language of the bill, which uses the word ingestion, that has been interpreted to mean that the lethal medications have to be taken into the gastrointestinal tract. This presents a couple of really big problems. First of all, most people end up drinking a thick liquid, which tastes terrible. Of course, nobody alive has ever tried it, but the reports are that it's extremely bitter, and apparently there has not been a good way to mask that taste. It's also quite caustic, and it can burn a person's esophagus as they're swallowing it. So this is a really kind of sad and miserable way to have to end your life, I think. Um, if a person can't swallow, can't take it by mouth, they can use a rectal catheter, but they still need to have enough strength in their hands to self-administer, to push a plunger. Um, there are people, particularly people with ALS, will often lose the use of their hands uh, so that they can't actually use the medication, even though they may qualify by being at that 6 months mark. If a person already has a feeding tube because of whatever disease they have, the medication can be introduced that way. But my husband at Pegasus died using an IV method, which we felt California should adopt. a medical professional put an IV line into his wrist. It was attached to a saline drip. And when he was ready, he turned a little dial that opened a valve and allowed the lethal medication into his vein. It was completely painless and very quick. I think he died within 2 minutes. That's another problem with the current method of ingestion because uh, absorption into the GI tract is slower and often is quite slow in people who have compromised GI systems because of their diseases. It can take many hours for a person to die. The dying person isn't bothered by this because there's a heavy dose of sedative included in the mixture of medications that they get. But a family can be sitting at a bedside for 4, 6, 8, 10 hours waiting for death to occur. And this is really stressful for a family. So the method, including an IV method, was the second thing we thought should be changed. And the third was we wanted a specific statement saying that a person with early to mid-stage dementia could be evaluated, and if they were found to have the cognitive capacity to make this decision, express it clearly, and understand the consequences of using medical aid in dying, that they should have access to the law. So those were our three changes that we thought should be made. And then we had to think about how could this happen? We thought of three possibilities. The first would have been a court challenge. We could have had a plaintiff, say a person with early dementia, who would say, I don't want to let the disease run its course. I want to have an assisted death, but the law is barring me from doing that, discriminating against me, however it would be phrased legally. The problem there is that it would have been extraordinarily expensive to hire the highly skilled attorneys we would have needed for a novel case like this. We're a tiny organization with an equally tiny budget, and it just wasn't possible. The second route we thought of was a ballot initiative. And we thought this actually might have succeeded because when public opinion polls have been done on the issue of whether people should have the right to end their life, if they feel the need to do it, public opinion has been overwhelmingly in support of that. Now, our specific requests haven't been polled, not yet anyway. Maybe we'll be able to do it at some point. But we thought public opinion probably would be with us on this. But unfortunately, mounting a ballot initiative in California is just wildly expensive. And again, it was far beyond anything we could tackle financially. So that left us with the legislative route. In other words, seeing if the California legislature could be persuaded to make a change in the law. And I'm going to turn it over to Barry, who will talk to you about that chapter of the story.
Barry will have you unmute and then we'll be ready to hear from you. So Barry, if you can unmute.
Okay, can you hear
Looks
me?
like you're good to go. You're good to go.
Good. First of all, Marcia, thanks for that great history of how we got started. I'd forgotten some of those things myself. Well, we did get started, as Marcia said, and we did decide to go the legislative route. And so my story is really the story of the effort to get those provisions that Marcia talked about, those amendments to the End of Life Option Act into law. And if you look at a chart that shows how a bill becomes a law, and I asked Sarah to put up a little graphic that I found in an old American government or state government text here. And just to, you'll see that how a bill becomes a law in California, the very first step is bill is introduced. Okay, Sarah, you can take it down now. Just But that's it. Bill is introduced. And you'll notice the language is in that passive voice. Bill is introduced, as if a bill magically gets introduced. In fact, of course, a bill has to be introduced by a member of one of the two legislative bodies in California, either the Assembly or the state Senate. So it was pretty clear that our first task was going to be finding somebody who was willing in those bodies, who was willing to introduce a bill that would incorporate the kind of changes we were talking about. And we had some ideas about where to look. We looked first of all at the supporters of Senate Bill 380. We thought if senators or legislators are willing to support Senate Bill 380, they might be predisposed to support the kind of more progressive version of Senate Bill 380 that we were recommending. So we started calling these folks, and we met typically with their staffers, oftentimes young people, but they oftentimes would give us a similar kind of message. They would tell us that their boss, their representative, was sympathetic to our cause. They thought it was a worthwhile thing to do, but there was nobody saying, and I think my boss would be willing to introduce that legislation. And the reason, of course, is because legislators tend to be kind of careful people. That is to say, they generally try and avoid controversy, at least the kind of controversy that might bring them some negative press. So we didn't have anybody jumping out to say, hey, I'll do that. And so then we kind of were feeling like, oh, okay, this is going to be a long slog to find somebody. And then all of a sudden, Hemlock's own Janet Hager struck gold. She ended up getting in touch with her own state senator. Her own state senator is Catherine Blakespear. And maybe you can put up Catherine's picture on the screen there for us, Sarah. Catherine Blakespear is a relatively new state senator. She was elected in 2022, and she is she represents northern San Diego County and southern Orange County, which means she has a lot of old folks in her district that are probably talking about these kinds of issues we're interested in. She also, it turns out, was an estate attorney or is an estate attorney. So she's also, for that reason, talked to a lot of older people who are probably thinking about these issues and trying to deal with these issues. So she was more attuned to this, and she let Janet know that she would be willing to, in fact, sponsor such a bill. So suddenly we had our legislative champion. And, you know, if you can maybe put her image back up there, that first page again, Sarah, I want to point something out to the folks here in the audience. If we can see it, let me see, scroll on down there if you can to the bottom of that page, or maybe even the second page. Let's go to the second page. No, I don't see it there, but you can find it very easily. I was going to recommend that those of you who are happy that she was our sponsor, she was our champion, might want to just send her a little email, and her email is on her website. So maybe that's where you can get it instead of trying to look through this. But we would like you, to be honest, it would be wonderful if you would send her a little email saying how much you appreciate the work that she's done towards this goal, because she really, in some ways, went out on a limb for us, and I think showed some real courage to do what she did, and we want to let her know how much we appreciate that. So at any rate, we had our champion, and we had somebody to introduce the bill, and really even much earlier than we thought really we might have, because we thought we might have to look for quite a while to find somebody. Well, once we had our champion, then we went to work on two main fronts here. And the one front was trying to get as many individuals and groups to express their support for this kind of legislation as possible. And we had a bit of a problem, because when Senator Blakespear first introduced the legislation, it was introduced as a placeholder bill. And a placeholder bill is basically consists of just a few short sentences saying, this is a bill that will amend the existing End of Life Option Act, or something to that effect. It's very short, very general, gives no details. And so for several weeks after she introduced the bill, there was really no bill to look at. We were looking at a blank page in some sense. So of course, when you go out to talk to groups, and we started calling groups, again, using the same strategy we did with the legislators. We started looking at first at the groups who supported Senate Bill 380. So we start calling them, and of course, the first thing they say is, well, we're sympathetic, we might be interested, show us a copy of the bill. Well, there was no bill to show them. So we said, well, I guess we'll have to get back to you when the bill's actually, available to show you. In some cases, some other groups were a little bit more open to hearing what exactly we were doing and sort of taking on faith that the bill would reflect what we were telling them. But other groups, understandably, wanted to see if they're going to write a letter of support for something. They wanted to see what that bill looked like. So we were stymied for a few weeks there, a few critical weeks before the Senate Health Committee was going to meet, because the bill was assigned to the Senate Health Committee. And so we were sort of stymied for a couple reasons. First of all, because we didn't have the exact language of the bill. And then secondly, we were stymied because many of the organizations that we were getting in touch with, as you know, they don't meet every day. It's not like their board meetings are every week. Some of you are in organizations, and you know that a lot of organizations have a board meeting, maybe every quarter, maybe every couple months, maybe even every month, if you're lucky. So, we ended up talking to organizations, then people in these organizations, and saying, hey, we'd like to meet with your board and explain what we're doing, and have you consider the bill? And of course, their response was, oh, well, sure, we'll put you on the agenda, but our next meeting is, after the time when we have to have the letters of support gathered up. So we ran into some significant obstacles as a result of that placeholder bill. But at some point, I think it was almost a month after the placeholder bill was put in, the actual wording of the bill came out, and we were able to see it. And then we were able to send these groups copies of the bill and try and recruit, a number of groups to support the bill, write letters that they submitted through the legislative portal, which the legislature has set up for that. Not as many groups as we would have liked, just because of the obstacles that I just mentioned to you. But you can see, if you put that second page of that document up again, Sarah, I'll show them the number of groups that supported us. Okay, you see, there's the groups. If you look right down at the bottom of that second page on the right under support, you can see the number of groups that supported our effort. And you can see there's a sizable number of groups that we were able to recruit, in spite of the fact that we were working under very, very difficult time constraints. And I think we have no doubt that with more time, we can greatly, greatly add to that list. So we're very confident that we'll expand that list as we go forward. But these were all the groups that supported us. If, by the way, you are a member of a group that isn't on that list, then, please, and you think might be sympathetic to this kind of an effort, please get in touch with us, and we'll try and talk to them and see if we can't get their name added to that list. Well, in any case, that was one of our efforts, trying to get these individuals and organizations to support. The second effort we were involved in was another one that was more directly with Senator Blakespear's office, because Senator Blakespear assigned her legislative director, Aubrey Rodriguez, to work with us on this bill. And once the language of the bill was set, we began to have very regular contact with Aubrey, because he was constantly talking to other legislators, mainly people on that committee, the Health Committee, trying to line up support for this bill. And of course, every time he talked to one of these legislators, or he talked to one of an interest groups that was concerned about this bill, he would get information about what they liked about the bill, what they didn't like about the bill, what they could possibly live with, and yet what they couldn't live with, what they absolutely were opposed to. And so every time he had this kind of a contact at the legislative offices, he was back in touch with us, trying to find the extent to which we were willing to alter the language of the bill, compromise in our language of the bill, to meet some of the objections being raised by those people, those legislators and interest groups he was talking to. So this kind of information flow went back and forth between us for about 3 weeks. And there were days when I think we had 2, 3, 4 emails back and forth between us. And so, it's almost like you had to be at your computer full time or you'd miss out. And so we, did as best we can. And he did try, he was a wonderful contact, and he did try to find some common ground between our interest and the interests of groups who were in opposition or legislators who were in opposition. And he, a couple of times he came to us and said, well, would you be willing to alter this part of the bill if we could use that to hold off some of the opponents or quiet them down? And we considered at various points in this process, we considered making some compromises in the language of our original bill, because we thought, a half a loaf is better than no loaf at all. And so we were willing to make some compromises if we could get a firm commitment from the groups in opposition to back away, at least be neutral, and let that bill go forward to and have a better chance of success in the Health Committee. Unfortunately, he was never able to get the kind of commitment from these opposing groups that we would have needed to begin compromising ourselves. And since there was no offer on the part of these opposition forces to compromise, there was no real sense on our part that it made sense to do so. So we didn't do that. And as a result, things moved towards the time when the Senate Health Committee was getting ready to meet. And we had, at that point, drawn upon the advice of what, Marcia mentioned as a kind of our kitchen cabinet of informal advisors. These were people who mainly Marcia had found through personal contacts, but these were people who had deep knowledge of the legislature and the legislative process. They were insiders. Oftentimes they were staff members who had worked many years in the legislature. And their advice was essentially, don't go to the Health Committee with that bill if you know you're going to get a no vote, because that'll make it harder to come back the following legislative session if you have on record a no vote. That was their advice. And so we thought, well, okay. A second piece of their advice was that even if you don't go to the committee hearing for a vote, you can have simply a hearing without a vote. And they recommended that we do that. And the reason they recommended we do that was because that would allow us to bring experts that we had identified into the hearing, and it would allow groups that opposed us or legislators that were leery of this bill to ask those folks questions and maybe clarify and maybe alleviate some of the fears they had about the bill. So that's basically what their advice was. Go for a hearing. And so we scrambled and got a hearing. We started thinking, okay, that's what we're going to do. And so we're scrambling and we're getting in contact with people we think would be great witnesses. And we did, of course, and we were so fortunate to have sympathetic people who were willing to come down and testify. We got in touch with Stephanie Green. As you know, Stephanie has talked to Hemlock at the Hemlock Society on various occasions. So she's been, she's very knowledgeable about this kind of stuff. And she's the president of the Canadian, what's it called? The Canadian Association for Medical Assessors and Providers of MAiD. Well, she was perfect because our bill was very much modeled on the Canadian bill. And so the thinking was she would be the perfect person to answer any questions or concerns these legislators might have in a hearing. We were also fortunate to get the help or the offer of help from Thad Pope, who, as all of you know, in Hemlock, because he's spoken with us before, is a legal expert on all of these end-of-life issues. So Thad would have been a wonderful, wonderful witness because he could have answered all these questions about legality and ethics and that kind of thing. So, and both of these people made Herculean efforts to make themselves available. They're very busy. They had scheduled stuff already. They canceled stuff. We got them air tickets down and from Canada and back from, I think, Thad was back in Michigan or someplace. And so we got them air tickets and we're ready to go. And then we find out at the last minute that the legislative leadership, and that presumably included the chairman of the committee, the health committee, Richard Roth, had decided they would not allow a hearing only meeting of the committee on this bill. And so suddenly, boom, this flash of lightning, and it was all gone because there was not even a hearing. And so we were so disappointed about that. And yet we all learned a tremendous amount from this experience. It was almost like a crash course in what you need to do the next time we go this route. So we really couldn't feel like it was a loss because we had gained so much rich knowledge about how the insider process works in the legislature. And it was a wonderful experience. So that was the story of Senate Bill 1196. It was a flash and then boom, it was gone. But we're coming back with something like Senate Bill 1196, and we'll talk about that a little further on down the line. I probably forgot something here in this presentation, but my time is probably up. So I think I'm going to cede back to Marcia, who's going to tell us about the opposition. Really, who were these people that were opposed to us? Who were these groups? And I'll let her take the floor. Marcia.
Thanks, Barry. Well, we knew from the outset that SB 1196 would draw opposition. We knew it for a couple of reasons. First of all, there are groups that historically have mounted court challenges to all end-of-life legislation in the US whenever it has been proposed. These groups are primarily the Catholic Church and organizations that are affiliated with them. You probably know there are a lot of healthcare organizations that are affiliated with the church, and disability groups who raise the concern that people with disabilities could be encouraged or even pressured to end their lives by using medical aid in dying rather than obtaining health care that they need. There are no documented cases of this kind of abuse, and there are pretty stringent safeguards in the law, which 1196 would have maintained. But of course, anyone can bring a lawsuit. Doesn't mean they'll prevail, but you're always entitled to try. But when you look back at California's law, which was passed in 2015 and implemented in 2016, the opposition of the religious groups and the disability groups didn't prevent passage of the law. And they did not prevent passage of SB 380 that Barry referred to. That was an amendment to the law passed in 2021 and implemented in 2022. And that amendment shortened the waiting time between the mandatory 2 oral requests for medication from 15 days to 48 hours. So both times, the original law and SB 380 were opposed by religious groups and disability groups. Both times they passed. But in the case of SB 1196, we were opposed by 2 extremely powerful groups, And we think it's their opposition that probably accounted for us not getting out of the starting gate this time. That's the California Medical Association and Compassion and Choices. We had hoped, as Barry said, that if they couldn't support the bill, they would agree to remain neutral. And that would have been a big plus for us if they had not actively opposed the bill. But they both filed official letters of opposition with the Senate Health Committee. And I think it's useful to talk a little bit specifically about what their opposition was. Now, keep in mind, these letters are not very long. There are things in them that don't make much sense to me, and I think they probably won't make much sense to you either, but I'm going to tell you what they are. Let's start with the California Medical Association. They said in their letter, CMA believes requiring a 6-month terminal diagnosis is an essential safeguard, and its removal fundamentally alters the current law by decoupling eligibility for the medication from being near the end of one's life and is a program more akin to euthanasia. Now, they're absolutely correct that the goal of the bill was to decouple eligibility from that arbitrary 6-month end of life requirement. But there's not one word in SB 1196 that has anything to do with euthanasia, which is the active ending of one person's life by a medical professional. That is allowed in some countries. It's not allowed in the US, and it would not have been allowed under 1196. So actually, I don't understand what that, where they get to that statement. They also objected to the definition of a grievous and irremediable medical condition as replacing the 6-month to death requirement. They felt it was extremely vague, and they said that it would include many conditions, quote, that might ultimately be terminal but immensely treatable. So let's look at what the language of the bill actually said. What conditions would a person have needed to meet to be considered to be suffering from a grievous and irremediable medical condition? There were 4. 1, and I'm going to read you the language of the bill. It's not great literature, it's legalese, but you'll see what I mean. Number 1, the condition is a serious and incurable illness or disease. 2, the condition has placed the individual in a state of irreversible decline in capability, and the individual's suffering is palpable without prospect of improvement. 3, the condition is causing the individual to endure physical suffering due to the illness, disease, or state of decline that is intolerable to the individual and cannot be relieved in a manner the individual deems acceptable, and there is no proven treatment for the individual's situation that the individual has not attempted or is willing to attempt due to the nature or side effects of the treatment. And finally, 4, after taking into account all of the individual's medical circumstances, it is reasonably foreseeable that the condition will become the individual's natural cause of death. A specific prognosis as to the length of time the person has left to live shall not be required to meet this criteria. That sounds quite specific to me, but it apparently seemed vague to the CMA. The other thing they went on to say that was really surprising to me when I read it was this, that SB 1196, quote, would require the physician to make a subjective determination as to whether the condition constitutes suffering that is intolerable to the patient. This is exactly the opposite of what the goal of the bill was. If 1196 had passed, doctors would not have been expected to make a subjective determination about the patient's suffering. Doctors would have been expected to take in the totality of the person's medical situation and then believe the patient when the patient said, I've reached a point where my choice is a dignified death rather than continuing to suffer with the condition I have. In other words, it sort of reverses, who gets to say when the suffering is too much? Should the doctor be allowed to make that decision? Or are we going to believe a person that is suffering from a condition? Finally, they objected to the dementia provision in 1196. And their statement is, quote, CMA believes that individuals must be of sound capacity to access life-ending medication to ensure that it is the individual's true choice. We absolutely agree with that statement, but it sounds like the CMA is suggesting, they don't really come out and say it, it sounds as though they're suggesting that no person with a dementia diagnosis would have the capacity to make this decision. We know that people in early and mid-stage dementia have the legal right to make medical decisions, legal decisions, all kinds of decisions. And the bill was not going to say anyone with a dementia diagnosis could access medical aid in dying. It said a person with early to mid-stage dementia could be evaluated, and if found to have the cognitive capacity to make this decision, would be allowed the choice. If you think back to those few sentences I read you that Ricardo said at Pegasus shortly before he died, that was impromptu. That wasn't something he thought about ahead of time or wrote down. That was a person with dementia who was very clearly talking about his choice and what it meant to him. So clearly we have some major differences of opinion with the CMA, and we'll see whether something can be worked out. Now let's talk about compassion and choices. Many people were quite surprised to hear that they opposed SB 1196 and were pretty upset about it. And we do know that some people have contacted Compassion and Choices and expressed their disappointment about that decision. We met with them, the senator met with them. We tried very hard to see if they would agree to remain neutral on the bill. They did not. They filed a letter of opposition, and ironically, this put them on the same side as the groups that have fought them very bitterly for years when they've tried to pass legislation. So they had three major arguments against the bill. The first was they felt that the current criteria need to remain in place, quote, to ensure that people don't feel compelled to access medical aid in dying because they lack availability to adequate pain management and symptom relief. Again, they don't spell it out, but it sounds like they're saying, well, if an assisted death is available to people before they're within that 6-month window, maybe they won't even look for palliative care. Maybe they'll just say I'd rather die. This doesn't really make a lot of sense to me. And the other interesting thing is that when people have been surveyed about either why they would choose medical aid in dying or why they have decided to choose it if they qualify under the law, pain control is not at the top of the list. It's pretty far down on the list. The reasons people give are much more likely to be concerns about loss of dignity, loss of control, loss of ability to make their own choices. The second argument that Compassion and Choices raised was the dementia issue. And they say, quote, though we recognize SB 1196 intends to provide more options for people living with dementia, it's imperative to approach this issue carefully and with compassion. However, expanding medical aid in dying is not a suitable solution. Well, we just have to agree to disagree with them on that because we think it is 100% the suitable solution for people with early to mid-stage dementia. They claim to have options for people with dementia, and what they have is something on their, you can see it on their website, called the Dementia Values and Priorities Tool. So this is what Compassion and Choices offers for people with dementia. this is a form you can fill out. It's not too different from a post form, if people are familiar with that form. I have one on my fridge. This dementia and values priority tool lists a whole series of things that can happen to a person as they develop and progress into a case of dementia. For instance, can't feed myself, can't speak, can't recognize my loved ones, can't bathe or toilet myself, a whole series of possible things that, or likely things that happen as a person develops dementia. And for each of these on the form, you check that whether you would choose to live as long as possible, to be treated but not treated aggressively, or be allowed a natural death. Now, keep in mind that this tool would only kick in if a person with dementia develops something else which is liable to end their life without treatment. Say they develop a pneumonia or some other infection. But many people live for years with dementia without another illness which could take their life if they choose not to have treatment in that circumstance. So, I mean, I suppose this is a useful tool for someone who feels okay about letting their dementia progress. It certainly would not have been a useful tool for my husband, who was adamant about not spending his last years in a memory care facility, and it wouldn't be useful for me. Finally, we get to the issue that is actually Compassion and Choice's main objection or main concern, I would say. And this is something they've raised multiple times in many forums. And that's their concern about litigation. Their concern is that if the law is expanded, there could be a successful court challenge and we might lose the law that we have. We might lose the gains that we've made, even though they're very restrictive. So let's take a look at what's happened in the state of California. As I said, the original law was passed in 2015. There have been two cases that could have potentially interfered with the law. One case was filed the day before it went into effect by some doctors that didn't like the law and a couple of organizations that tend to oppose this kind of legislation. And they said the law should be thrown out because of the way it was passed specifically. The original law in 2015 was passed during a special session of the legislature rather than a regular session. It was a special session dedicated to healthcare. And these plaintiffs said that the bill exceeded the scope of what should have been discussed in that special session so that it should be invalidated. Now, this case took a number of years. It went through various permutations. Just in brief, at one point, a judge said, yes, the plaintiffs were correct. It was passed incorrectly because of the special session. And the implementation was actually interrupted for, I think, a month or two until Compassion and Choices filed an appeal and the court reinstated the law while the case was being heard. Subsequently, an appeals court said that the plaintiffs didn't have standing. Now, let's review for a minute. I didn't go to law school. I went to psychology school, but to have standing in a law case means that the party seeking a legal remedy has to show that they have a sufficient connection to the law and harm from it to bring a case. And these plaintiffs were found by the appeals court not to have standing. So the case was sent back to the trial court, and the plaintiffs were in the process of filing another suit to try to improve their standing. But when SB 380 was passed in 2021, that's the amendment that reduced the waiting time between oral requests, that was passed in a regular session of the legislature. And that made the argument about the special session moot. So the plaintiffs agreed to dismiss that case. That case went away. Last year, in the spring of 23, disability groups challenged the law and said the law should, again, be nullified because it was coercive, it was encouraging people with disabilities to seek suicide rather than medical treatment, and rather than provide them medical treatment. By the way, just a note about language: whenever you hear in relation to this kind of legislation, when you hear people talking about suicide, mercy killing, doctor-assisted suicide, you are almost always hearing from the opponents, because we don't use that kind of language. You will never hear us use the word suicide, because an assisted death is very different from a suicide. Again, the plaintiffs in that case were found not to have standing. So that's two cases where standing was a hurdle that couldn't be jumped. There was a third case, and I'm just going to mention it briefly because it was much narrower. This was also last year. A group of doctors who were opposed on moral and religious grounds to participating in the law in any way said that the requirement that they report a patient's request for the lethal medications infringed on their First Amendment rights. And the state settled that case. It didn't change anything in the law, but the state said they would not insist on documentation from doctors who were opposed on those grounds to participating in the law. Those doctors are now supposed to refer a patient to a provider who will participate. So that's really been the situation since 2016. Two cases where plaintiffs didn't have standing. A third case that the state settled on that narrow issue of documentation from certain doctors who don't want to participate. Again, I certainly don't have legal expertise, but I think the standing issue is a hurdle that's going to be very, very difficult for plaintiffs to surmount, because, as I said, people have tried to look to see if there have been any cases of coercion or abuse, and none have been found. And that's what a plaintiff would need to establish standing, as I understand it. So I wouldn't disagree with Compassion and Choices that there will be litigation. If we're able to expand California's law, I think we can absolutely expect that there will be people bringing court cases. But I don't know that they will succeed. And I think the bottom line is that we can't let a concern about litigation stop us from trying to improve the law for the citizens of California. It's just not, doesn't make sense to me that you would do nothing because somebody might sue to knock down the law. So that's the story of the opposition. And I think the real question moving forward is whether we'll be able to find enough common ground with these very powerful organizations so that in the future, hopefully, they will agree to not oppose us. I'm going to turn it back to Barry, who will talk to you a bit about what we are looking for in the future.
Well, thanks so much for filling us in on the opposition, Marcia. Thankfully, my last segment is very brief, and it's brief, and that may be a good sign or a bad sign. It's a good sign for the audience, but a bad sign, I think, for us and Abe. The question is, where do we go from here? Well, our goal in a better exit is to, of course, reintroduce the same kind of legislation as SB 1196 in the next legislative session. And that would be in 2025. And the ideal time to introduce that legislation would be in early 2025, so that it would have 2 years we'd have 2 years to try and find a way to get that bill through the California legislature as opposed to 1. Now, that means we have to find somebody to, again, introduce the legislation. Our hope, of course, is that Senator Blakespeare will do exactly that. We're hopeful. She's told us she's interested in setting up a working group that will consist of ourselves and other people that are in organizations in this space that are interested in this legislation, either opposed or for, and that we can work out some sorts of compromises. So hopefully she will do that introduction of the bill again. If not, we'll be back looking for other sponsors, or even if she will sponsor, we'll want additional sponsors. So that's one of our tasks. A second task, and in many ways a more important task, is to develop a much longer list of groups that are going to support this kind of legislation, and a much greater number of individuals that will. In the long run, and again, if you could put that graphic back up, Sarah, again, of the legislative process, if you can put that up there, the other, that's it. Yeah. I don't want to bore you with this because, if you've had any experiences with government classes, you might have some phobias that are causing you grief right now. But in any case, you can see this process of getting a bill passed and making it law is an incredibly long process that requires lots of effort, lots of resources. We're struggling just to get a committee hearing, a positive vote out of a health committee. You can see that there are many, many steps after that. The floor of the institution, that is, the Senate, would have to approve it. Then it would have to go to the Assembly, and it would have to be approved there, would have committee hearings, and then floor action. So there's a whole lot of steps in this process. They're going to take a lot of time, and so therefore, we don't have hopes that this is going to happen very quickly. What we do hope is that when we take this to the legislature next year, and we hope to do that we will have developed a bigger base of support. And legislators ultimately will hear and feel that support, either through letters from their constituents or organizations that get in touch with them, organizations in some cases that even fund them, contribute to their campaigns. So we expect in the long term that we will simply build the support necessary for this bill. And I think all of us that are involved in ABE are involved for the long haul. We know this is going to take years to get to where we want to go. And we're willing to invest in that. And we're hoping that some of you are willing to invest with us in that. And of course, we can use, as you can see, given all the work ahead of us, and given that we have 4 people on our board, as well as a number of informal volunteers, you can see that we can use as much volunteer help as we can get. And so any of you who might be interested in working on this issue, I hope you'll get in touch with us so we can put you to work as well, and put your shoulder to the wheel so we can move this whole process forward. And I know we want to leave a lot of time for questions, so I'll leave it at that. But before I do, I want to ask Sarah to play a short video of the kind of people that inspire us to work for this thing that we see as so important, this progressive end-of-life option.
Hello, my name is Barbara Riverwoman from Santa Cruz, California, and I'm 86 years old, and I'm thinking a lot about my last days, and especially since my 2 sisters, younger sisters, are both pretty far advanced in terms of dementia. And so the California laws regarding end of life won't cover me if I also miss my window or don't know or don't have the capacity to make a decision. So I really support better exit.
Thanks, Sarah. That's the kind of person we run into on a regular basis, and that's what drives us, and we hope that's what will convince you to put your shoulders to the wheel. And with that, I guess we'll open it up for questions.
Wonderful. Well, thank you, Barry, and thank you, Marcia, for sharing your experience.
Huge thank yous to all of you. This is just so enlightening. I'm obviously retired, but in my working career, did a lot of work in the legislature, and we, in the early years, just kind of experienced the horrors of going up to Sacramento as somebody not well versed in what you need to do to get things done up there. And finally, somebody said, "Well, why don't you just hire a lobbyist?" And I thought, well, duh, yeah, we should hire a lobbyist, which we did. And that made all the difference in the world. I realize money is an issue here, but what I learned is that just having somebody roaming the halls of the Capitol, available for a spontaneous, spur of the moment opportunity to talk to someone, kind of the face of the organization, made all the difference in the world. And our first lobbyist kind of had a couple of rules that he lived by, but one was incrementalism. And I know that you're thinking about that, but so you can't get everything done, in that 1 year. And thankfully, we have a full-time legislature, and it's a 2-year legislative session. So his big thing was, incrementalism, maybe not go for the whole big package, but go for one thing now and then another year. And in the meantime, you're kind of softening up the opposition, or at least maybe gaining more proponents. So that's just a couple thoughts of sharing from our lobbyist. And then I'm just wondering, you mentioned the importance, Barry, of adding to that list, which is which is already impressively long, but perhaps seek some religious groups that would be in line with the goals of this legislation, given the unfortunate, power of the Catholic Church and other religious groups that would be opposed. And I was just very, very disturbed to hear of the California Medical Association's opposition. That I'm sure must be really tough to overcome. But anyway, those are just some of my thoughts, and I'm done. Thank you.
The incrementalism, I think I tried to mention in my talk, we had been willing to take some of this things that we were hoping to get in exchange for a commitment from the opposition to either remain neutral or at least soften their opposition. And unfortunately, we couldn't get that. So I think you're right. We're certainly open to incrementalism, and we would be willing to cut back on some of our demands, I think, if we could get the kind of commitment from our opposition that we would need to do that. And in terms of your comment about a full-time lobbyist or a lobbyist, yes, wonderful. We'd love to have one, and unfortunately, as I think, Marcia mentioned, our funds are pretty meager. So most of the work has fallen to ourselves.
We had a few more questions related to groups that might support future legislation. So someone asked about AARP. And then there was another question about whether supporting organizations needed to be based in California.
Sarah, we were told that organizations and individuals could be anywhere, even from outside the US, so they don't need to be based in California. I believe we did reach out to the AARP. Barry, correct me if I'm wrong, but we did not make any headway there.
I think they emphasized that they were neutral on this. They didn't seem to be opposed, if I remember right, but they seemed to want to remain neutral on this kind of a question.
We had a question in the chat about if it would be possible to develop a website with stories from people who, or stories of what people are doing to end their life who don't qualify for the law.
That's an interesting question, and I don't know about a website, but one of the things we've talked about that where we don't have data is the question of how many people end their lives because they don't qualify. And of course, we don't have a way of understanding if you look, say, at suicide in a certain age group, how many of those are from psychological problems, impulsive acts, how many of them, and we certainly do know of some cases, are people who don't qualify for the law and decide to shoot themselves or die some other way, which is really sad and unfortunate. But it's hard to tease those things apart and get the information.
Along similar lines, we've had some questions about what people can do now to express their support for future legislation. So is it useful for people to contact California legislators, contact other organizations? What can people be doing right now as they're waiting for a new bill to be introduced?
I think, can you hear me? Am I good to talk? Okay. I think that there's a lot of things people can do. I think certainly writing your representative is a very useful thing to do. And especially if you write the representative and you send us a copy of that letter, because the more of those we can pile up, the better off we are. And I think also it just lets these legislators know that this is an issue that their constituents are thinking about. And legislators are very they have their fingers in the wind all the time. That's why they hire those staff. And one single letter probably wouldn't make a difference, but if they get 10 letters on the same topic from their 10 different constituents, that starts to get some attention. So yeah, I think writing your legislator is really useful.
And we had a question about whether someone who does not live in California, if having them write a lawmaker in California is effective or not.
Probably not. In fact, the way you contact your legislator in California is through their website. It's standardized across the legislature. And I think you actually have to be a constituent. If I'm not mistaken, you actually can't get that email onto the portal if you're not a constituent.
We have a few more people who want to ask their questions live. Don Hill, if you'd like to go ahead, and feel free to turn your camera on if you'd like.
Okay, it's challenging enough to get voice. Can you hear me?
Yes.
I don't look that good anyway. So thank you for the thoughtful presentation. I have a simple question, and that's, you're dealing with the law in California. As far as I know, law about medical practice is on a state level. So are there 50 states doing what you're doing, or 49 other states? And then what happens on the federal territory within a state, like the VA system, which it's a federal situation? How does all that play out?
Well, I can say a little bit about that. Each state is going to, healthcare is generally been a function that is under the purview of the states. And so healthcare tends to be, dominated by state legislation. And there are certain aspects of healthcare that might raise federal questions, but generally it's a state by state issue. And so obviously the kind of end of life policies that you find are going to vary tremendously from state to state. So in terms of your other question about federal facilities in a state, you'll find, for example, that the Veterans Administration is a good example. It's not covered by state legislation. So in other words, people who are part of the veterans healthcare system aren't covered by state policies that deal with end-of-life issues.
Well, if there's 50, could they shop around? Like if California doesn't have a good state law on this? Maybe Vermont does. And I mean, how do they have 50 different rules?
Well, that's what people have started to do, to be honest. I mean, there are states, as you probably know, that most states don't have any kind of end of life option act. And so people in some of those states have begun to find a way to drift towards states that do have these laws. And there was a court case recently, and I can't remember the exact name of it, but it was a court case which essentially decided that people who lived on the border, I think it was a Washington and Oregon, or maybe Idaho and Oregon, I can't remember, that came across for their health care into Oregon, if they could then benefit from the End of Life Option Act in California, even though Idaho didn't have one, or the other state, I think it was Idaho. But in any case, and the law basically, a court case was dealt with this, and the court held that they could. So now there are people who can come from out of state to California, or to Oregon or some of these other states that have that. And it looks like the state will be open to people coming from out of state.
Just to clarify, the Oregon has dropped its residency requirement, and that was in response to a lawsuit from a physician who actually practiced in Oregon, but some of his patients were in Washington State, very close. And he had a patient who wanted to end his life and have this doctor help him, and the doctor wasn't able to. So they brought a court case, and Oregon settled. Vermont has also dropped its residency requirement. California still has a residency requirement, which means that if somebody wants to use medical aid in dying here, they have to establish residency, whereas for Vermont and Oregon, people can travel there and without establishing residency and in their life.
We have a question about California specifically, and whether California is the right state to be introducing medical aid in dying legislation that goes beyond what other states have already passed.
That's a great question, because we think California is exactly the right place. The reason is that California has been more progressive than other states with respect to certain kinds of legislation. Certainly, if you think about climate control legislation. And so our hope actually is that if we can get change in California, it will affect other states. States very closely watch what's happening in other states. And we can already see this happening with what we just talked about a minute ago, which is the residency requirements. When Oregon's requirement for residency fell, Vermont followed soon after, and there are other states that are talking about dropping their residency requirements for medical aid in dying. So we think if we could get a law that would allow an assisted death for people with, competent people with dementia, other states would follow. So we think California is the right place.
We have another live question. Marla Jensen, go ahead and ask your question.
It's John Jensen, and Marla's here too, but I am going to ask this because Marla and I are together in all of this. Okay, firearms notwithstanding, there have to be drugs involved in the end of life procedure. Why? Has anyone thought about getting in touch with the pharmaceutical companies that provide these drugs to provide money to our organizations so that we can do lobbying or whatever else we need to do with the money? And before you say, oh no, we can't do that, let's just remember that Donald Trump has set up all of these sidebar websites to collect money for his defense fund. So anybody thought about that?
I know we haven't thought about it. We haven't thought about writing the pharmaceutical companies asking for them to fund our efforts, and part of the reason is obviously we, and I suspect the pharmaceutical companies have some concern about their own image in terms of promoting, death in some way, and they're funding that effort. So I'm guessing that they would stay away from that, but you may be right. It might be worth a try. We desperately need funds. There's no question about that.
Well, all they can do is say no.
Yeah.
And also, as I said, if we were able to set up some little side fund that they could send the money to that didn't have objectionable language in it, maybe they would. But as I said, all they can do is, the worst that they can do is say no.
Sure. Yeah. Well, an interesting thought.
We have a question for you, Marcia, if you're open to answering it. And the question was about why you and your husband made the choice for him to pursue aid in dying in Switzerland versus using an advance directive to indicate that he wanted to stop eating and drinking closer to the end of life, or that he would actually begin voluntarily stopping eating and drinking.
Sure. We did consider that. That's VSED, voluntarily stopping eating and drinking. My understanding is that VSED can be a fairly long and difficult process, particularly if a person is in pretty good physical health, which my husband was. And I mean, I used to make jokes and say, my family loves food. Starving somebody is really not the way we want to go with this. I felt it would be very, very difficult for me. My husband probably had the determination to do it, but I didn't want to put him through it, and frankly, I didn't want to go through it. We were fortunate. I mean, I probably should have said this earlier. One of the problems with going to Switzerland is that not everybody can do it. Not everybody can afford it, and not everybody is physically able to make a long trip. We were able to go on both of those accounts, and we considered ourselves very fortunate. But, I know there are people who successfully use VSED, and if a person is really debilitated and can't travel, it's an option. But it certainly isn't ideal, I think. And I guess our feeling is it's a shame that that's what people have to resort to when we're so much more humane in our treatment of our pets than we are in our treatment of each other at the end of life.
We have a question from Faye Gersh, our founder of Hemlock Society. Faye, go ahead.
Hi. About 28 years ago, when I was head of the National Hemlock Society, right after the Supreme Court voted 9-0 that we do not have a constitutional right to aid in dying, we started the Caring Friends program as part of the National Hemlock Society. And we knew that was going to be very difficult to get doctors to prescribe drugs. And so Derek Humphrey, our founder, had already said, had already written in Final Exit, the book, that the inhalation of an inert gas was a good way to go. And so we started that program called the Caring Friends program, where we instructed people on the use of the inhalation of inert gas. When we finally merged, the National Hemlock Society dissolved actually in its merger and became Compassionate Choices. We also became Final Exit Network. Final Exit Network is now 20 years old and does not rely on doctors prescribing medications. It does rely on the inhalation of inert gas, particularly nitrogen at this point. It started out with helium. So that's another way related to the previous question, that people can go to end their lives and they can go through Final Exit Network.
Actually, I think FEN is a wonderful organization. I'm a member of that too. We actually didn't know about FEN at the time we were making our decision. But I also think, had we known about it, I don't know whether we would have chosen it. But also, I think my husband might have been anxious about doing it properly. Certainly, I think it's working well for a number of people, and it's great that that's an option that's out there.
Thank you both, Marcia and Barry, for taking the time to speak to us today about your efforts to bring an expanded medical aid in dying law to California. We've reached the end of our time today. The recording of this video will be available on the Hemlock Society website within a couple of days. And feel free to send any additional questions that you have about SB 1196, future efforts to expand our laws, or medical aid in dying in general. You can send those to the Hemlock Society, and we'll be happy to get you answers by email.